So to my fourth then, and I'm determined, my final video in this series on Article 40, Section 1. I'm going to talk about those two cases I mentioned in the first video. The O'Mara case, O'Mara and the Minister for Social Protection, and the EW case, ZG and EW against Ireland. O'Mara's from 2024, EW's from 2025. They're interesting cases for illustrative purposes. I will deal with those cases briefly. I don't really want to get into them in great depth. You can read them yourselves, and you should. But there's two little bits from Donnelly I need to pick up or clean up, tidy up. The first bit from very late on in her judgment, which I actually didn't reference in earlier videos, and I should have. Paragraphs 192 and 193. I just draw your attention to them. You can read them yourselves. Paragraph 192, I think the lines in the back end of that from O'Malley's judgment are the ones that will likely be cited into the future, in the sense that she re-articulates essentially Henchy's thesis, and you're familiar with the concept already, so I won't dwell on it, but she says, I consider therefore that the challenge can only succeed if the legislative exclusion is grounded upon some constitutionally illegitimate consideration, and thus draws an irrational distinction, there's the rationality test, resulting in some people being treated as inferior for no justifiable reason. In other words, if there's a reason, it's okay. If there's no justifiable reason, it's not okay. The Constitution doesn't permit the court to determine that the plaintiff should be included simply because a more inclusive policy would have been fairer. So that's the recapitulation, as I said in the first video, of what had been there previously. But I do think O'Malley articulates it in a very coherent and thoughtful way. So that's why Donnelly is such a big judgment. The other point really that I just neglected to mention up until now, and I do think it's interesting and relevant and will be important into the future, is that she introduces, she doesn't introduce it. This had been there previously as well in earlier case law, like in Brennan and the Attorney General, or in Thomas Slab Murphy's case, Murphy against Ireland, I think 2014. The notion that the courts would be willing to lower the threshold in some contexts, specifically in contexts where the legislative discrimination or classification, if you like, was based on some so-called suspect ground, like on the grounds of ethnicity, for example. In other words, there are some dubious classifications or distinctions drawn between categories of citizens where, like sexual orientation, for instance, or religious belief, discriminations or classifications that were made historically for no good reason or for hostile, irrational, arbitrary, egregious kinds of reasons. Of course, this wasn't directly applicable in the Donnelly case itself. I mean, the Donnelly's lawyers sought to argue that the discrimination at issue was one that was based on disability, as we saw. And disability, I think, would certainly be a quote-unquote suspect ground for this purpose. In other words, it's a kind of as it were, an quote-unquote immutable characteristic, such that it would count as a suspect ground. It's a bit like skin color or religious belief or sexual orientation or gender. In other words, I suppose disability, like those other things, is something that historically has attracted contempt, let's say, or has attracted dismissal or disregard or even hatred. And these are, as it were, suspect grounds. And that's an American phrase, American constitutional concept, the suspect classification, suspect ground. And what O'Malley is saying is, she, for reasons I won't get into, she doesn't want to quite go down the American route. She talks about that and why not. But she is saying that it's there latent in the Irish jurisprudence that when the legislature makes classifications on those kinds of ground, that is suspect. By that she means the courts will lower the threshold for judicial, will be more intrusive in their scrutiny. Now again, she stresses that context is important. She says it should be borne in mind that context is relevant here, and also that some grounds of discrimination, even within the core category of characteristics of human personality, are more likely to be offensive than others, and thus require more intense scrutiny. But her point is, as she says later in paragraph 194, the reason that grounds concerning those intrinsic aspects of human personality are considered suspect is that differentiation based on such grounds may in fact be the result of either irrational prejudices or groundless assumptions. In my view, the obligation of the court under 40 section 1 includes ensuring that groundless assumptions or prejudices have no role in determining the legal rights of individuals. So again, like I say, that doesn't seem terribly important in the context of cases like O'Mara or EW or of course Donnelly itself, because you're not dealing with legislation that distinguishes between people on the basis of, contempt for a particular category of citizens, or disregard or hatred or whatever. They're more routine, run-of-the-mill kinds of classifications. But in the future, potentially, though that aspect of the O'Malley judgment could be quite significant. That takes us to the O'Mara case. I mentioned in the first video that it was a tragic case. The O'Maras were a family from County Tipperary. I think the dad, John O'Mara, was an agricultural contractor. Michelle, his life partner, as she was described in the court judgment, they had met, they never married, which is important, and I'll get to that. They had met sometime in the early 2000s. They commenced this relationship. It was a committed, stable, long-term relationship. I mean, they were together for 20 years. They lived together. They had these 3 children together. The children were maybe young teenagers, perhaps 10, 12, 14, that kind of age, when sadly she got cancer, then contracted COVID-19 and died, I think, in 2020. They had never married, as I said. Michelle, her parents had a difficult marriage and had separated. She didn't want that as a result. Tragically, I think in the weeks before she died, or perhaps it was months, they had discussed marriage, but time ran out, which kind of adds to the tragedy. On her death, he, John O'Mara, was ineligible for the widow's pension. Actually, it's called the widowers, or surviving civil partners contributory pension, which is governed, of course, by legislation by the Social Welfare Consolidation Act 2005. If they had been married, of course, he would have been eligible. And as I understand it, it would have been worth to their household, it would have been worth, I think, $1,200, maybe a little more per month. There's a pension payable to the surviving partner of the marriage, let's say, or the surviving civil partner. But then for each child who's a dependent child, and all 3 children were dependent children, there was an additional payment, if you like, or entitlement. And as I say, it would have been worth about €1,200 to the family, to the household per month, but they were ineligible. And so they claimed, or John O'Mara claimed, that this exclusion, or the discrimination in treatment between him and, say, somebody who was in the same situation but who had been married to his partner, was a breach of Article 40, Section 1. So I guess what you have here then is an applicant, a plaintiff, who is very, very close to the line, but who's outside the line. Remember that point. It's intrinsic in the process of legislating to draw lines between different categories of people. The Oireachtas does it every time it enacts legislation. And what John O'Mara and his 3 kids essentially are doing here is they're going to the court and they're saying it's unfair that the Oireachtas have drawn the line quite where they've drawn it. They should draw it around us to include us. Why would we be excluded? And of course, as you know, this is not a case of, it couldn't be said to be a case of discrimination based on a suspect class of ground, in the sense that unmarried couples, I don't think you could say unmarried couples historically are the subject of hatred or contempt or disregard, or have been targeted historically in the way that, for example, people with a certain skin colours have been in different contexts targeted historically. So it's not a suspect classification. So the rationality test is certainly the test that's going to apply here. So you might say, sure, it's unfair. You might say, sure, it's unjust. But is it irrational? Isn't the state entitled to incentivize marriage? If you're being very cold about it, you could say, couldn't the O'Maras, didn't they have the choice to get married if they wanted to? They had 20 years to do so and they never did. And now, I mean, that's a very, very cold analysis, but I'm bringing it back. How do they win? How do they cross the the threshold. Now, as you know, they did. So how did they do it? Well, perhaps it was that they had excellent lawyers who were diligent and thorough in how they analysed the legislation. I imagine that is the case. Certainly, if you look at the judgment of the Chief Justice Donald O'Donnell, in 7 paragraphs, from paragraph 27 through to paragraph 35, he sets out the detail in a forensic way of the legislative arrangements around this. It wasn't straightforward, it wasn't simple. And he draws the conclusion that actually the exclusion of the O'Maras was not just unfair, but that it was actually irrational. One of the features of the legislative framework that he identifies as important is that the pension, the widow's pension, the widow's contributory pension, terminates on remarriage or on entry into a new civil partnership. In other words, if you're a husband and your wife dies, you become entitled to the pension. If then subsequently, let's say 18 months later, you remarry, you're no longer entitled to the pension. Similarly, if you begin to cohabit with a new partner, you're no longer entitled to the pension. Another feature, a similar feature of the legislative framework, is that it's payable in respect of the death of a divorced spouse. In other words, if you're married and you get divorced, and then subsequently, let's say 6 years later, your ex-wife, ex-husband, dies, then you're eligible, then you qualify at that point for the payment, even though you were divorced and potentially divorced for many years at the time of her death or his death. And yet you can see how this is going to the notion of the irrationality of the exclusion of the O'Maras, in the sense that that couple wasn't married at the time of the death of one of them. Similarly, John O'Mara wasn't married to Michelle Beatty, but in John O'Mara's case and Michelle Beatty's case, they had been living together in a committed, stable family relationship for 20 years at the time of her death. The point being, I suppose, ultimately, that the exclusion of the O'Maras wasn't just unfair, it was irrational. The point really actually being, to be a bit more analytical about it, that the purpose of the support, the purpose of the pension, when you reflect upon it in the light of its details, was to support the person that's left on their own responsible for the household, not necessarily financially. In other words, the idea being that where at one point there were 2 sources of support, adult support, it might be a husband and a new cohabiting partner, for example. It might be a wife and an ex-husband, for example. Whatever the details of it, the pension is available where the 2 goes down to 1. And it becomes unavailable when the 1 goes back up to 2, if you like. And yet in the O'Mara's case, in other words, it didn't really have to do with marriage as such, And yet in the O'Mara's case, 2 went down to 1 on Michelle's death, and yet John O'Mara was ineligible, which wasn't just unfair, but actually irrational in the light of the purpose of the legislation. So that's ultimately, and it was really good lawyering, I would say, that meant that the O'Maras were able to kind of demonstrate to the court, well, look, it's not just a bit unfair. It's not just that the line should arguably be drawn over here. It's that in the light of what the legislators did and how they had tweaked it and designed it and so on, that it made no sense actually to exclude the O'Maras. Therefore, it was irrational. Therefore, it was unconstitutional. So they won their case. So actually, it was a straightforward enough case, the O'Mara case. But it shows how the rationality test isn't insurmountable. And I think similarly, it shows how the legislative exclusion doesn't have to be kind of heinous or, that language that Henchy uses, capricious, kind of suggests conniving kind of in bad faith almost on the part of the legislature, that it has to be actively seeking to treat some group with hostility before the courts will intrude. But it doesn't have to be like that. My impression from the discrimination at issue in O'Mara is that it was more like almost an oversight on the part of the Oireachtas, that there was no principled objection to including people in the category of the O'Maras, almost like as if the Oireachtas would say, well, if we thought of that, or if we'd kind of been made aware of it, or if we'd kind of seen it, well, of course we would draw the line to include them. So it kind of gives us a better understanding, I think, of the reality of the rationality test in Article 40, Section 1 cases on the ground.